This is a major misstep, in my opinion, and it's probably going to be in the opinion of some of the political pundits out there, because now this is no longer just a Justin Trudeau's Liberals issue. Now, Mark Carney and his government have actively decided that they are going to appeal this. So Mark Carney has put himself next to Justin Trudeau. We have breaking news, folks. Mark Carney's Liberal government is taking the Emergencies Act fight to the Supreme Court of Canada, appealing a landmark ruling that found Ottawa's use of the law during the 2022 Freedom Convoy unconstitutional. Lower courts had already ruled the government did not meet the legal threshold for a national emergency and that it violated charter rights, setting up what could become a historical Supreme Court showdown over executive power in Canada. Let's take a look. Liberal government appeals Emergencies Act decisions to the Supreme Court. Ottawa. The Liberal government is honking its final horn in its legal battle to validate its invocation of the exceptional powers of the Emergencies Act to deal with the 2022 Freedom Convoy protests. Tuesday, Prime Minister Mark Carney's government filed its application for leave to appeal to the Supreme Court of Canada in the hopes that the highest court in the land overturn two earlier decisions against Ottawa. In its filing, the federal government argued that the federal court and federal court of appeal applied the quote-unquote wrong principles and a quote-unquote flawed approach when it concluded that the government's unprecedented decision to invoke the Emergencies Act on February 12, 2022 was unconstitutional. Now, just a reminder for everybody, when you're talking about appealing decisions and it's going up in the chain of courts, remember that they're not retrying the entire case and they're not calling witnesses to testify, and in most cases, they're not re-reviewing evidence. What the goal and the role of the appeal courts and the Supreme Court is to review how the lower courts actually executed the law. And did they actually get the law correct? So what the Federal Court of Appeal, what they argued is that Mr. Mosley's decision, Justice Mosley, who was the Liberal appointed judge that actually ruled in the first place that it was unconstitutional, they said he was completely correct in how he applied the law. And the issue was all coming down to basically one thing, is that the Emergencies Act is invoked based on a threat to national security. And that threat to national security is defined in only one place, the CSIS Act. And we've gone over that multiple times, so I don't think we need to go over it again. But they concluded that, yes, that was absolutely correct. And therefore, mainly on that alone, but never mind the rest of it, it wasn't justified to actually execute it. But the Federal Court of Appeal did comment on the fact that seizing bank accounts was absolutely against charter rights, and there was no justification to do so, was unconstitutional. And the way they applied these powers wasn't correct. So all of that was confirmed by the Federal Court of Appeal. So the role of the Supreme Court would be to just look at, did the lower court apply the law correctly? And then did the Federal Court of Appeal apply that law correctly? The government also argued that the Supreme Court needed to make a final decision after the two courts came to different conclusions than the Public Order Emergency Commission, which found in 2023 that the invocation was reasonable. Quote, while the nature and purpose of the POEEC differed from those of the court proceedings below, their opposite conclusions create inconsistency and underscore the need for this court's intervention and guidance, end quote, reads the application. In January, the Federal Court of Appeal upheld a lower court decision that the Liberal government's invocation of the act to deal with lingering quote-unquote freedom convoy protests was unreasonable, unjustified, and violated the charter. Hear, hear. The challenge was brought forward by civil liberties groups such as the Canadian Civil Liberties Association and the Canadian Constitutional Foundation, as well as the provinces of Saskatchewan and Alberta. And for those interested, you can check out our interview with Christine Van Geyn, who is one of the folks that represents the Canadian Civil Liberties Association that actually brought this challenge forward. We interviewed her a couple of days after the appeal decision was dropped. At the time, the government argued it needed the exceptional powers granted by the Act to freeze some convoy participants' bank accounts, compel tow truck companies to cooperate with local police, clearing out blockades, and mark parts of downtown Ottawa as a no-go zone. But in 2024, the federal court ruled that the government's decision that those powers were unnecessary to deal with the blockades at two border crossing, Coutts, Alberta, and the Ambassador Bridge in Windsor, Ontario, and downtown Ottawa. In fact, Federal Court Justice Richard Mosley determined that existing provincial and municipal powers were sufficient to address the disruptive protests. In his decision, Mosley agreed that with the government that the pan-Canadian protests in early 2022 were causing harm to Canada's economy, trade, and commerce. But he concluded that the damages did not rise to the level of a threat to national security as defined by the law to invoke the exceptional and heavy-handed powers of the Emergencies Act. And as we've talked about in multiple videos, economic harm actually does not fit within the definition that is outlined in the CSIS Act to justify invoking the Emergencies Act. Quote, the record does not support a conclusion that the convoy had created a critical, urgent, and temporary situation that was national in scope and could not effectively be dealt with under any other law of Canada, end quote, he wrote. Quote, the harm being caused to Canada's economy, trade, and commerce was very real and concerning, but it did not constitute threats or the use of serious violence to persons or property, end quote, he added. In January, the Federal Court of Appeal upheld the decision, also finding that Prime Minister Justin Trudeau's cabinet did not have reasonable grounds to believe that the convoy created a national emergency. Quote, we are of the view that cabinet did not have reasonable grounds to believe that a national emergency existed, taking into account the wording of the Act, its unconstitutional underpinning, and the record that was before it at the time the decision was made, end quote, wrote the court's Chief Justice Yves de Montigny. Now, the Supreme Court of Canada must decide if it will hear the case. But the federal government faces a high bar for its appeal to be heard because there was no disagreement between the federal court and Federal Court of Appeal, meaning there are no major legal questions to be answered by the Supreme Court of Canada. Critics of the court are also likely to raise questions about Supreme Court of Canada's Chief Justice Richard Wagner's comments months after the Freedom Convoy, arguing that type of protest should, quote-unquote, never happen again. During his annual press conference in 2022, Wagner described the impact of the Freedom Convoy's blockades on many Ottawa businesses and individuals, particularly, quote, the most vulnerable, end quote, as, quote-unquote, deplorable. So, this brings up some interesting points. The government's arguing, well, our public inquiry came to this conclusion. And that's at odds with what the court was saying. That's not right. So we need the Supreme Court of Canada to come in. Supreme Court of Canada doesn't care about the public inquiry at all. And it's good that this article actually raises this. The Supreme Court of Canada is going to look at what the lower court said versus what the Federal Court of Appeal said. And they were both in complete agreement. There wasn't really any wiggle room on their judgment of what happened with the Emergencies Act. Justice Mosley had, I think, the biggest heavy lifting to do, and he wrote a very long and detailed argument and decision. So that when it came to the Federal Court of Appeal, they were looking at it, and they were seeing that, hey, he nailed it. He absolutely nailed it. And they came to the exact same conclusion. So first, this is brought before the Supreme Court of Canada, not to review the decision, but just to try and argue that you should give us the opportunity to present it to you in order for you to hear or to review the decision to possibly overturn it. So the first is a hearing that they have to attend to convince the Supreme Court, yes, you should hear this. And that's going to be the difficult part, because they have to argue that on a legal basis, the Federal Court of Appeal and the lower court did something wrong legally. That's basically the reason you argue for the Supreme Court of Canada to look at this? And I don't think they're going to find a reason. They're going to argue that, the public inquiry said this, but I don't think the Supreme Court of Canada is going to care about a public inquiry. That's great. You can have political motivations, you can have a whole bunch of different factors in a public inquiry. That is outside of a court, and it doesn't actually rise to the level of burden of proof that a court needs. So that's one aspect. The second aspect is many political pundits had actually guessed that the Carney Liberals are not going to appeal this. And I would have expected them not to appeal this as well. Why? Because it would have allowed this to essentially die with Justin Trudeau and Trudeau's government. This is a major misstep, in my opinion, and it's probably going to be in the opinion of some of the political pundits out there, because now this is no longer just a Justin Trudeau's Liberals issue. Now, Mark Carney and his government have actively decided that they are going to appeal this. So Mark Carney has put himself next to Justin Trudeau in believing that this was absolutely constitutional and this was appropriate for the time. Canadians' bank accounts should have been seized. Now, many of you are going to say, well, yeah, we thought that Carney would have, believed that anyway. But the important point about this is that that's you can believe that, you can have that as an assumption. This is now documented. The fact that they're doing this, that he believes that. Otherwise, as the Prime Minister, he could say, no, we're absolutely not going to be appealing this. I don't want to deal with this. This is a huge political misstep for Mark Carney, because now you have his government advocating for the Emergency Act use being constitutional. He's disagreeing with both the Federal Court of Appeal and the lower court. So this is not a smart political move for Mark Carney for that respect, but also it's wasting more millions of dollars of taxpayer money. And that taxpayer money, given that Mark Carney says that we're in an economic crisis of our lifetimes, wouldn't that be better spent on things like houses, Mr. Carney, like your food program that your Liberals keep crowing about? But no, you want to spend it on lawyers, and you want to spend it on government lawyers in order to try and prove that your buddy, your pal, the guy you were advising, Justin Trudeau, was absolutely correct in suspending the freedoms of Canadians across this country, using powers that have never yet been seen used in a Western nation, that shocked the rest of the world when they were used. And Canadians that know Mark Carney know about his op-ed where he made his feelings known about the Freedom Convoy. Quite clear. But now, as a government, he's standing side by side next to Justin Trudeau and saying, I believe in suspending the rights of Canadians. And he's doing so, allowing for there to be no ambiguity. This is no longer opinion. This is no longer belief. Ladies and gentlemen, what he's doing is stating to everybody that, no, it is now a fact.